Hello guys, welcome to this MCQ series of paper 60 economic laws. My name is Ayush and in this video we are going to solve the case study number 3. So let's start with the question. We are directly jumping to the question and then we will refer the case study for finding out the answers of the question. We will not be reading the entire case study. Okay. So let's see. Yes. So question number 1, whether the PPL can withdraw the application earlier filed by it under section 9 of the IBC 2016 before the adjudicating authority. For that we first need to understand what is exactly happening. So if you can see, PPL made the application under section 9 of IBC 2016, got admitted by the adjudicating authority, initiating a corporate insolvency resolution process. Okay, so the CIRP application was admitted by the adjudicating authority, but after what they have given is that lot of information is given, but from here you can see adjudicating authority made an order appointing an interim resolution professional, and the first meeting of the committee of the creditors was also had also taken place. Okay, so CIRP was admitted and also the committee of the creditors was also constituted. So after the constitution of the committee of the creditors, if some applicant wants to withdraw the application, 90% of the approval of the 90% of the voting share of the COC is required for making the application for withdrawal. So here they have given is that the PPL that their dues will PPL feels that their dues will be hardly satisfied and hence they apply to NCLT for a withdrawal of the application filed earlier. Okay, so since they feel that their dues will not be recovered, they want to withdraw from CIRP process. So this is the this is the legal provision. After constitution of COC with 90% voting share, the COC shall consider within 7 days of receipt of the applicant IRP or RP to apply within 30 days, 3 days of approval by the COC. So application for withdrawal. Okay, so if you want to make an application for withdrawal before adjudicating authority, which is after the constitution of COC, you require approval of 90% of voting share in COC. Here they have not given any percentage. Here if you can see, they have not given any percentage of approval. So we can say that whether they asked whether PPL can withdraw the application earlier filed by it under section 90. Okay, so only they are asking this legal provision only. So yes, it is this is not correct, this is not correct, 66% not, 90% is required. Okay, so option D is the correct answer. Yes, by adjudicating authority, but only at the application from the applicant, PPL in this case, with the approval of 90% of the voting share of the committee of the creditors. So if you want to make an application for withdrawal of the CIRP process, you have to obtain the approval of 90% of the voting share of the committee of the creditors. Question second, what shall be the legal validity? Yes, what shall be the what shall be the maximum penalty with which Miss Ankita can be punished as punished on being accused as Benamidar? So from question we can sense that Miss Ankita is being accused as Benamidar. For this we have to refer the question. So here they have given the details. Miss Ankita bought a luxurious flat apartment for herself at a cost of 1.15 crores out of the funds sponsored for the trust of the university. Okay, The property was shown to be purchased at a price of 35 lakhs to the sub register of properties in order to save the stamp duty. Okay, so the property was duly registered in the name of Miss Ankita at the fair value on the date of registration was 1.20 crores. The transaction came in the scanner of the authorities and the said transaction was declared as Benami transaction, and Miss Ankita was accused as Benamidar in the final order passed under the relevant provisions of the Prohibition of Benami Transaction Act 1988. So here Miss Ankita, who has bought uh, the flat, but it has registered the flat in the name of sub register, she is being accused as Benamidar. Okay, if you have studied the prohibition of Benami Property Transactions Act, you know that there is a rigorous imprisonment for entering into a Benami transaction, which will, if you don't know, you can simply refer this legal provision sheet and you can read from here. Okay, so yes, punishment: whoever is found guilty of an offense of Benami transactions referred to above shall be punishable with an imprisonment, with a rigorous imprisonment, okay, for a term which shall not be less than 1 year but which may extend to 7 years. Okay, so 1 to 7 years, and okay, so and is very very important. So he will be imprisoned also, and he will be liable to fine also, and liable to fine which may extend to 25% of the fair market value of the property. So in the given question, Miss Ankita is already accused as Benamidar, so she will be imprisonment for a rigorous imprisonment for 1 to maximum 7 years, and she will be liable to fine of 25% of the fair value of the property. So many people might get confused between fair market value of the property on the date of the order was 1.40 crores and fair market value of the property on the date of registration was 1.20 crores. We have to consider the fair market value of the property on the date of registration, which is 1.20 crores. So 25% of 1.20 crores comes to 30 lakhs. So yes, so 30 lakhs, and we have to see rigorous imprisonment. And okay, this and is very very important because both punishment will be given, that is she will be sent to jail for 7 years as well as fine of 30 lakhs. So B is wrong answer because they have given, or option D is the correct answer. Question third: whether DDRL is required to, yes, so option D is the correct answer. Question third: whether the DDRL is required to register the real estate project Light under the RERA Act. So there is some real estate project called Light. We have to see whether it is required to be registered under RERA Act. For that we have to know the more details. Yes. So from this part of the case study they have asked the question. So project Light will comprise of 8 wings. 8 wings means 8 separate buildings of 6 floors each, including the ground floor. Each floor will have an independent apartment with a carpet area equivalent to 80 square meters. Okay, so each floor will have only one apartment, that is independent apartment means only one apartment. The base area to be developed is 125% of the carpet area, which includes parking area and a garden. Finally, it is decided by the board of directors that phase wise development. Okay, so as you know, in real life also the phase wise development takes place. So the board of directors have decided that the project Light will be developed phase wise. That will be the right choice for the DDRL for implementing the project Light. Okay, so 8 buildings, 6 floors each, and on one floor there will be only one apartment. So for this you need to know what is the exact legal provision under which the property is required to be registered under RERA. Okay, so let's refer the let's refer the legal provision. So as you can see, section 3 subsection 2 contains certain exemptions from registrations. Okay, So from this we can conclude that all the real estate projects are required to be registered except these three exceptions. That is, if the project is satisfying the legal requirement given here, you need not be registered, but in all other cases you have to take the registration compulsorily. So you don't have to take the registration if the area of land proposed to be developed does not exceed 500 square meters, so it is not relevant for our case study, and the number of apartments proposed to be developed does not exceed 8 inclusive of all the phases. Okay, so whenever you are calculating the total number of apartments, you have to include the total number of apartments from all the phases. Okay, so some students might feel confused that only 6 floors and one apartment on each floor. So only 6 uh, flats are being constructed, but we have to consider the whole project, inclusive of all the phases. Okay, so if you can see in the given case of project Awas, there will be 8 wings into 6 floors and into one independent apartment, okay, on each floor. So there will be a total of 48 flats. So since 48 is exceeding 8 inclusive of all the phases, we have to, that is promoter has to compulsorily take registration for the project light. Okay, so yes, option C is the correct answer. Whether DDRL is required to be registered the real estate project light under ERA. Option C, yes, because in aggregate 48 units to be constructed considering all the phases. Okay, so this is a very important question, and option C is the correct answer. Whether there is any violation of law by Mr. Joshi in respect of remittance of an amount equivalent to $2,75,000 in foreign currency to his daughter Miss Ankita during the financial year, and if yes, then what shall be the penalty that may be levied. Okay, so as per FEMA Act, under liberalized remittance scheme, you can remit an amount equivalent to $250,000 without any approval. But here Miss Ankita Joshi, the daughter of Mr. Joshi, is studying international business from the University of Sheffield, London, UK, and Mr. Joshi remitted an amount equivalent to $275,000. So Mr. Joshi has exceeded the limit of 250,000. So and here they have not given any that the Mr. Joshi has taken approval of the RBI. Those details are not given, so we can safely assume that Mr. Joshi has violated the provisions of FEMA Act. So we have to refer what is the penalty for violating the provisions of the FEMA Act. So this is the relevant legal provision. Section 13, contravention of any provision of the Act, rule, regulation, notification, direction, order or condition subject to which authorization issued. So fine or penalty will be 3 times the sum involved if it is quantifiable. If the sum involved, that is what is the exact violated amount, is not quantifiable, then penalty would be 2 lakhs, and for continuing default the penalty would be 50 lakhs. So in the given case, what has happened is that the allowed limit of remittance is $250,000. The actual amount that is remitted is 2,75,000. Since the excess remittance is of 25,000, and since the amount of sum involved is quantifiable, this first provision will be applicable, and the penalty would be 3 times the sum involved. Sum involved is 25,000. 3 times the sum involved is equal to $75,000. Okay, so option C is the correct answer. Mr. Joshi violates the law and penalty levied may be up to $75,000. Some students might be confused between option B and option C, but since the amount of is quantifiable, 3 times the amount, that is 75,000 is the correct answer and not 25,000. Question 5th. How many registration the DDRL needs to take under RERA for its project as aforementioned if any of them are required to be registered? Okay, so we have to see how many project is being constructed by DDRL. So one we have already covered. So DDRL is the construction company. It is constructing the project light, which we have already covered, and it is being constructed in a phase wise manner. That is, one building is considered as one phase, and total 8 wings will be constructed in 8 phases. So for the project light, 8 wings, 8 phases, and each board of directors have decided that phase wise development will be done. So each phase will be considered as a separate registration, and for project light 8 registrations will be required. And one more detail is given is here, project Awas. Okay, so there is a project called project Awas which was completed in the year 2005. Okay, so there was another project by DDRL which was called project Awas. It was already completed in the year 2015 before the completion certificate regarding which was obtained prior to the enforcement of RERA. So since here the completion certificate was obtained before the enforcement of RERA, so technically this project Awas is not required to be registered under the RERA Act, as completion certificate is already obtained before the enforcement of RERA. But after some time they have given the extra information. Awas, the DDR due to wiring of fiber optical that was under the ground of the side of the roads. Yes, at the board meeting it is also decided to perform some major renovation and redevelopment work at the project named Awas. Okay, so at the project Awas, which was already completed, some redevelopment and renovation work will be carried on. DDRL decided to do the necessary renovation in the roads and the drainage system, and also certain amount of redevelopment works in the area of community, etc., etc. Some of the flats which remained unsold at Awas will be advertised for resale after the redevelopment work gets over. So if you know the exception, there is also one more exception. If the project is being redeveloped, it need not be registered if that project is not advertised. But since here Awas, which is being renovated, some unsold flats are there, and those for selling those flats, advertisement will be carried out. So for selling the unsold flats at Awas, advertisement for sale will be done. Advertisement for sale after the redevelopment work gets over. Okay, so since these unsold flats will be advertised, Awas is required to be registered. If these were not advertised, Awas need not be registered. So total of 9 flats are a total of 9 registrations. Okay, so they are asking in this question how many registration the DDRL needs to take under RERA for its project as aforementioned, if any of them. Okay, so as you can see in the given case, building light 8 wings, 8 phases, hence 8 registrations, and building Awas 1 registration is required, as the unsold flats will be advertised. Okay, I am repeating, advertised for sale after the redevelopment work gets over. Okay, so 8 plus 1, total 9 registrations are required. And if you have any doubt why separate registration for each phase is required, you can refer this legal provision. All the doubts will be cleared, which is taken from page 2.29 of the ICAI study material. May 22. Okay, so in this way we have completed our case study number 2. Thank you. Do share your feedback and don't forget to like, share and subscribe. Thank you.